The High Court chamber grew hushed as Justice Amy Coney Barrett leaned forward, her sharp eyes fixed on Representative Jasmine Crockett. The normally calm justice's voice sliced through the air. "Congresswoman Crockett, you have repeatedly said this case is about protecting our democracy, but your own words go against the very Constitution you promised to uphold," Barrett said, her tone pointed and accusing. "How do you explain such clear hypocrisy to this court and to the American people?" The room collectively drew a breath. Seasoned reporters froze, their pens motionless above their notepads. This was unheard of. A Supreme Court justice was directly challenging a sitting congresswoman during oral arguments. The air was thick with suspense as cameras captured Barrett's stern face and Crockett's brief look of surprise. But then, something unexpected happened. Instead of backing down, Representative Crockett slowly stood, straightened her jacket, and walked to the microphone. What she took from her folder next left Barrett visibly shocked, and would change the path of one of the most important constitutional cases in decades. No one could have guessed that in the next quarter hour, Crockett would not only stand her ground, but completely turn the tables on Barrett with evidence that would leave the whole Supreme Court panel speechless. Before we dive deeper into this amazing clash, please take a moment to hit the like button and subscribe to our channel for more real political analysis that the major news networks won't give you. Click the notification bell so you don't miss our special reports on the biggest political fights happening right now. Justice Amy Coney Barrett sat straight at the Supreme Court bench, her black robe perfect, her face serious but collected. At 53, Barrett had become a conservative legal star since her controversial confirmation in 2020. The former Notre Dame law professor and mother of 7 had been President Trump's third Supreme Court appointment, solidifying the court's 6-3 conservative majority. Legal experts often praised her sharp mind and strict originalist approach to the Constitution. Today's case involved a challenge to a new voting rights bill that Representative Jasmine Crockett had pushed through Congress. The law was meant to increase ballot access and federal oversight of state election rules. Conservatives saw these policies as federal overreach, while progressives saw them as crucial protections. The stakes were as high as they could be. If Barrett and the conservative majority struck down the law, Republican-led states would keep more control over their election rules. If the law stood, federal standards would change voting access across America before the upcoming presidential election. For months, conservative media had been painting Crockett as a radical, pushing an unconstitutional plan. "She's trying to take over elections through the back door," read headlines on right-wing news sites. Fox News commentators wondered whether Crockett, a former civil rights lawyer before entering Congress, was intentionally weakening state authority. Representative Jasmine Crockett, 43, had moved up quickly in politics after winning her Texas congressional seat in 2022. The former public defender and state representative had gained national attention for her strong advocacy and sharp legal arguments. With degrees from both Rhodes College and the University of Houston Law Center, Crockett had a reputation as someone who came fully prepared and wasn't afraid to face her opponents directly. "I don't back down from bullies, whether they're in state legislatures or on the highest court in the land," Crockett had told reporters the week before. "This bill simply makes sure every eligible American can use their constitutional right to vote without needless obstacles. Anyone who opposes that should explain why they are scared of American citizens voting." These comments had apparently bothered Justice Barrett, who had been unusually outspoken during earlier hearings, suggesting the law represented a federal overreach into state matters. A constitutional line she believed should not be crossed. As the Supreme Court session started that morning, the chamber was packed. Legal experts from both sides filled the gallery. CNN and Fox News had reporters outside, ready to broadcast reactions. The moment the hearing concluded, constitutional scholars had predicted a routine, though tense, event following standard Supreme Court rules. No one saw what was about to happen. The Solicitor General had just finished her opening defense of the Voting Rights Bill when Justice Barrett unexpectedly turned her attention directly to Representative Crockett, who was sitting in the front row of the gallery. "Before we continue, I'd like to speak to Representative Crockett directly," Barrett said, breaking normal court rules. Chief Justice Roberts looked surprised but did not stop her. As Barrett continued, "Congresswoman, you've supported a law that fundamentally changes the balance of power set up in our Constitution. You have publicly said this court has no business looking at laws passed by Congress on voting rights. Your exact words on CNN last month were, 'The Supreme Court needs to stay in its lane.'" The chamber grew tense as Barrett's criticism grew. Such statements show a troubling disrespect for the constitutional separation of powers, the very foundation of our republic. Court observers exchanged shocked glances. This direct confrontation was nearly unheard of in Supreme Court proceedings. The Chief Justice shifted uncomfortably, but stayed quiet as Barrett continued her pointed critique. "Representative Crockett, you have built your career on claiming to defend constitutional principles, yet your legislation seems made to get around the Constitution's clear assignment of election authority to states. This contradiction needs an explanation." It was a political and legal ambush broadcast live to millions of Americans. Conservative commentators in the room could barely hide their satisfaction as Barrett carefully laid out her case against both Crockett and the voting rights law. What no one knew was that Representative Crockett had seen this coming and had come ready with evidence that would shock the court and the nation. The Supreme Court chamber remained frozen in shocked silence. Justice Barrett's unprecedented direct challenge to Representative Crockett hung in the air. The Chief Justice, finally getting his composure back, leaned toward his microphone. "While this is very unusual," Roberts began, "since Justice Barrett has spoken to the Congresswoman directly, I will allow a brief reply before we go back to the proper process." All eyes turned to Representative Crockett, who nodded politely to the Chief Justice as she rose from her seat in the front row. Her expression showed not fear, but calm determination. Court security at first moved to stop her, but Roberts waved them back, letting Crockett move toward the attorney's podium. "Thank you, Mr. Chief Justice," Crockett said, her voice steady and clear. "And thank you, Justice Barrett, for your direct questions. I welcome the chance to answer them." Barrett's expression remained serious, but a flicker of surprise crossed her face at Crockett's composed manner. The Congresswoman wasn't rattled as expected. "Justice Barrett," Crockett began, "you've suggested I don't respect the Constitution and this court's authority. With all due respect, my position has been wrongly portrayed." Conservative Justices Alito and Gorsuch exchanged doubtful looks. Justice Thomas leaned back, arms folded. On the liberal side, Justices Sotomayor and Kagan watched with deep interest. Crockett continued, "My CNN comment about the court staying in its lane was specifically about hypothetical questions, about the court possibly overturning the certification of election results, something completely different from reviewing the constitutionality of legislation." She reached into her folder and held up a transcript. "The full interview shows this context clearly. I have never questioned this court's judicial review authority established in Marbury v. Madison." Justice Barrett frowned. "Congresswoman, no matter that specific comment, your law tries to federalize election procedures that the Constitution clearly leaves to states. Article I, Section 4 is clear on this matter." Attention in the chamber grew. This was turning into a direct debate between a Supreme Court justice and a member of Congress, something never before seen in modern court history. "Justice Barrett, I'm grateful you have cited Article I, Section 4, Crockett replied, a hint of certainty in her voice. "Because that very section says, and I quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations." She emphasized the last part, her legal training obvious. The Constitution explicitly gives Congress the power to set up federal election regulations. My law works precisely within this constitutional framework. Several reporters frantically scribbled notes. This was not just a response, it was a constitutional counterargument delivered directly to a Supreme Court justice. Barrett's expression hardened. "Representative Crockett, I am very aware of the constitutional text. The question is whether your specific rules go beyond Congress's regulatory authority and interfere with core state functions." "I understand that concern." Crockett nodded. However, Supreme Court precedent has consistently backed Congress's broad authority in this area. She quickly cited 3 previous cases, supporting congressional action on voting rights. The exchange was becoming a high-level constitutional debate. Justice Kavanaugh leaned forward, clearly engaged by the substantial legal arguments coming from this unusual confrontation. Barrett shifted her approach. Your public statements suggest this law is meant to target specific states whose policies you personally disagree with. That raises serious equal sovereignty concerns under Shelby County v. Holder. The Crockett didn't hesitate. Justice Barrett, I have been very careful about this difference. Unlike the rules struck down in Shelby County, this law applies uniform standards across the nation. It does not single out specific states. The gallery whispered. Crockett was holding her own against one of the court's sharpest legal minds. Barrett pushed harder. Yet you have repeatedly said certain state laws are Jim Crow in new clothes. That suggests a targeted goal. Describing historical comparisons is different from writing targeted legislation. Crockett responded. The bill's text applies equally to all states regardless of my personal views on certain state laws. Justice Kagan nodded slightly, appearing impressed with the legal accuracy of Crockett's answers. Barrett changed tactics again. Your law includes provisions for Department of Justice preclearance of certain state election changes. That framework was specifically declared invalid in Shelby County. For the first time, a small smile appeared on Crockett's face. Justice Barrett, you have raised an excellent point that lets me clear up a key difference. She took another document from her folder. The preclearance part in this law is fundamentally different from the Section 4 coverage formula struck down in Shelby County. This bill sets up objective, current criteria that apply ahead of time to all states equally, directly dealing with the constitutional flaw identified in Shelby County. The legal reporters in the room looked stunned. Crockett wasn't just defending herself, she was giving a masterclass in constitutional law that directly addressed the court's previous concerns. Barrett's expression remained serious, but her tone had changed slightly. This wasn't the easy takedown of a politician's weak legal arguments she might have expected. She was in a deep constitutional debate with someone clearly knowledgeable about the court's own precedents. Representative Crockett. Barrett continued, and even if your law technically avoids the specific issues in Shelby County, it still represents a massive shift of authority from states to federal agencies. The Constitution's federalist structure suggests the framers intended a more limited federal role. Crockett nodded respectfully before answering. Justice Barrett, I share your commitment to constitutional loyalty. That is precisely why I would like to bring in something important to your concern. She took a bound document from her folder. This is a detailed historical study of the framers, understanding of congressional power over federal elections, including statements from Madison, Hamilton, and others. Several justices raised their eyebrows. Crockett went on, these sources show the framers specifically meant for Congress to have final authority over federal election regulations as a check against state manipulation. Alexander Hamilton specifically warned in Federalist 59 that without this congressional power, the national government's exclusion from regulating federal elections would leave the Union's existence at the mercy of state governments. The historical evidence was persuasive and clearly unexpected. Justice Gorsuch, known for his interest in founding era understanding, leaned forward with clear interest. Barrett persisted. Historical evidence aside, Congresswoman, your public support has suggested courts should simply defer to Congress on these matters. That is not how our constitutional system works. I agree completely, Justice Barrett, Crockett replied, surprising many observers with her quick concession. Judicial review is essential to our constitutional order. My concern has never been about this court's review authority, but rather about making sure that review is based on the Constitution's text and history, including the Reconstruction amendments that significantly changed the federal-state balance regarding voting rights. The conversation had now gone on for nearly 10 minutes, far longer than the brief reply Chief Justice Roberts had approved. Yet Roberts made no move to step in as the substantive constitutional debate went on. Justice Barrett, seemingly determined to find a weakness in Crockett's position, changed focus again. Representative Crockett, you've consistently said state voter ID requirements are unconstitutional barriers. Yet, this court has upheld their validity in Crawford v. Marion County. Your public comments suggest you hold contempt for that precedent. This accusation hung in the air, possibly more damaging than earlier points. Questioning a politician's knowledge was one thing, suggesting they disrespected court precedent was another. Crockett took a careful breath before answering. Justice Barrett, I have never said that all voter ID laws are unconstitutional. My concerns, consistent with this court's precedents, focus on implementation details that can create unfair burdens. She reached for another document. In fact, during my time in the Texas legislature, I co-sponsored a bipartisan bill that included voter identification requirements with proper accessibility provisions. My position has been consistent with the balancing test this court set up in Crawford. Justice Barrett seemed momentarily caught off guard by this evidence of Crockett's more moderate legislative record. The mood in the chamber had changed. What began as a justice's attempt to challenge a congresswoman had become a sophisticated constitutional discussion that was captivating the entire court. But no one was ready for what Representative Crockett would reveal next. Evidence that would completely shift the dynamics of the hearing and leave Justice Barrett genuinely speechless. The Supreme Court chamber remained completely silent as Representative Crockett reached once more into her folder. Justice Barrett watched with narrowed eyes while the other justices leaned forward, fully engaged in this unprecedented exchange. Justice Barrett, Crockett said, her voice now carrying a quiet self-assurance. You've questioned my respect for this court's authority and precedent. I want to address that directly. She withdrew a document that seemed to be a law review article. I have studied your academic work extensively, including this 2017 article you wrote for the Notre Dame Law Review called Precedent and Jurist Credential Disagreement. Barrett's expression registered surprise as Crockett continued. In this article you wrote, and I quote directly, I tend to agree with those who say that a justice's duty is to the Constitution, and that it is thus more legitimate for her to enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it. Crockett let the court hang in the air before continuing. You further stated that the public response to controversial cases like Roe reflects public rejection of the idea that stare decisis can declare a permanent victor in a divisive constitutional struggle. Murmurs went through the chamber. Crockett was quoting Barrett's own academic writings about the limited power of precedent, effectively using Barrett's past words to counter her criticism about respecting court precedent. My point, Justice Barrett, Crockett continued respectfully but firmly, is not to criticize your thoughtful scholarship, which I genuinely respect. Rather, it's to show that constitutional interpretation naturally involves principled disagreement, something you yourself have powerfully defended. Barrett's face remained composed, but the slight tension in her jaw showed her discomfort at having her own words used against her so effectively. But Crockett wasn't done. She pulled out another document. Additionally, I'd like to address your concern about federal overreach into state election administration. She held up what looked like a printed email. My office submitted a Freedom of Information Act request regarding the development of model election legislation by various organizations. We received this communication between the Heritage Foundation and state legislators explicitly stating their model voting bills were designed to ensure partisan advantage regardless of demographic voting patterns. The chamber burst into gasps. Several journalists rushed out to report this revelation. This document, Crockett continued, once the room had quieted, shows precisely why the framers gave Congress ultimate authority over federal election regulations as a check against state manipulation for partisan advantage. Justice Sotomayor leaned forward. Representative Crockett, is that document part of the official record in this case? It was filed in our supplemental brief last week. Justice Sotomayor, Crockett confirmed. Page 47, Appendix C. Chief Justice Roberts frowned, flipping through his papers to find the reference. Several other justices did the same. Justice Barrett tried to regain control of the exchange. Representative Crockett, a single email does not establish a pattern of You're absolutely right. Justice Barrett, Crockett interrupted politely but firmly, which is why we've included 17 additional communications in Appendix D detailing a coordinated, multi-state effort to restrict voting access specifically in communities with high minority populations. She didn't wait for a response before continuing, but most relevant to today's discussion is Appendix E, which contains communications directly citing your confirmation to this court as the green light to implement Phase 2 of the Election Security Initiative without fear of judicial interference. The chamber went completely silent. Crockett had just revealed documents suggesting certain state officials viewed Barrett's confirmation as permission to implement voting restrictions they believed she would uphold. Justice Barrett's face flushed. "Representative Crockett, I had no knowledge of." "Of course not, Justice Barrett," Crockett said quickly. "No one is suggesting you are personally involved. These communications simply show why the Voting Rights Act has been necessary and why Congress must